Law that criminalises children who possess or use cannabis has been declared unconstitutional, and it's a scathing ruling handed down by the Gauteng High Court, saying the way in which some children are treated 2 years after dacha was decriminalised is redolent of apartheid laws. From the Centre for Child Law, Karabo Ozah, good afternoon to you and welcome. How did this end up in court in the first place, given that this is a 2 year, all of this was sorted, I thought, 2 years ago?
Well, thank you for having me. I think the first point to make is that we must remember the Prince judgment actually specifically excluded children. So the judgment came out and it said that we're decriminalizing personal use of cannabis, but this does not apply in relation to children. So then what happened is that we got invited as amicus in this case when a magistrate who saw that children were being put in facilities for up to a year and a half and 2 years for having tested positive for cannabis or having been found with cannabis in their possession, were being sentenced to child and youth care center, which are meant for children who have committed serious offences. And he sent the matter on review to the High Court and said that there needs to be an intervention in relation to how these children were treated. And when we went into the case, we then raised the issue of the constitutionality of the Drug and Drug Trafficking Act insofar as it applies to children.
Was this widespread? Were a lot of children facing sanction in this respect?
So there is quite a lot, and I mean we're talking only about a particular region in Gauteng. So what we found is that places like the formerly known as Busasa Youth Child and Youth Care Center, the Walter Sisulu Youth Care Center, and another third new youth care center had quite a number of children. I mean they had up to in their 50s, or even a bit more than that, who ended up on diversion programs that are residential, so meaning that they have to leave home and be put in these facilities for up to almost 2 years because they tested positive for cannabis. And more importantly, this is the other very important aspect from the judgment, they tested positive on school premises. We know under the law, the Schools Act and the guidelines and the regulations there, when a child tests positive on school premises or is found in possession, they're not supposed to go through the criminal justice system. Actually, they're supposed to go through the treatment that is provided for under the Children's Act or the Prevention and Treatment of Substance Abuse Act.
So what then does the court ruling ultimately mean? For instance, a child now with a record, would that be expunged?
So they didn't get records, but they got diversion. So remember, with diversion, you must admit that you've committed you've done something wrong, and you acknowledge that, and then you are put on a program. And then once you complete the program, what happens is that you come back and you're supposed to then say you've completed it, and then that's noted, and it doesn't end up with a record. But because these children end up in the facilities, that's something that has been noted against them. So the judgment is very clear about what the officials need to do to make it clear that these children are not offenders. Now and also going forward, how we, the Departments of Social Development, the National Prosecuting Authority, Department of Education, how all of them must then deal with children who are found in possession of cannabis or who test positive on school premises. Well, as a start, but generally as well, that no child in the country can then, going forward, be charged under the Drug and Drug Trafficking Act. It does still need to go to the Constitutional Court for confirmation, though, this particular section that the High Court found unconstitutional.
Just a final one, and with that caveat, and I do understand it, do you have any concern that this ruling might not filter down to those people who perhaps have been abusing it?
Well, people who were actually putting children in these facilities were all put to task through the process. The judges were very, very clear. They made them attend the hearing. They made them report on what they're doing. And actually, the order itself in the judgment lists a whole lot of people, including magistrates, prosecuting authority, everybody who needs to know that the way they've been dealing with these children is no longer the way they can do that. So the judge made it very clear. They made it very clear in the judgment.
Thanks for the explanation. Karabo Ozah from the Centre for Child Law, Monday lunchtime on ENCA.